Believe it or not, it is the end of February 2026. My name is Oreku Frimpon and I welcome you to another edition of the Community and the Law. This afternoon, we're looking at why EUSS applications are getting refused and what the solution could be. BWF Solicitors is helping us bring you this one live. Lawyer Charles Asma, solicitor and partner of BWF Solicitors, is our guest and resource person. Let's get into this together. Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345. Or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpon and I am your host.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
And we are live on BWTV, bringing you the community and the law. My name is Oreku Frimpong. Good afternoon to you, and once again, welcome to the show. BWTV is bringing you the community and the law, and this afternoon we're looking at a very interesting topic. Now, if you are an EUSS person, let me put it that way, that will make you understand. These days, we have the understanding that some applications are being refused. Why are they being refused? And if the situation is like that, is there a solution to that? That's going to be our topic for discussion this afternoon when we invite in Lawyer Charles Asma of BWF Solicitors to help us with that. BWF Solicitors is located on the fourth floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters in North London. N15 4NP is the postcode. Now, I've showed you where they are. Let me tell you what they do. They are a legal firm with the sort. They know what they are doing, especially when it comes to immigration matters. They are on top of it. They give you the very accurate piece of information that you're looking for. And then again, they tell you what it is that you have to do to make sure your applications are successful. If your application is not successful, you have been denied that, and you want to put in a protest, or you'd want to challenge it in cost, let me put it that way, then they will help you put that in as well. When it comes to business support and advice, BWF Solicitors will help you with those ones. When it comes to family matters, BWF Solicitors is also available to help you discuss issues around your marriage, divorce, and what you can do with your marriage. And if you are divorced, what happens when you put in an application for your stay here in the UK. BWF Solicitors, they work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. You can call them on 0208 493 7340. I take the number again, 0208 493 7340. In emergency situations, you can call them on 077 127 61884. 077 127 61884. BWF Solicitors are trusted partners when it comes to the law. People have used their services and are so grateful they do that. And I would want you to develop the habit of saying thank you to BWF Solicitors. You can go on to their social media platforms at BWF Solicitors, and you can leave a comment there. And also, you can put in a question if it is that something is bothering your mind. And you go on Google and you can give them and leave them your reviews as well. BWF Solicitors, we are open to listen to you. We will work with your feedback and also make sure that things are going right for yourself and for the community. What they do as well is most of the time there is an issue that goes around and people want to have explanations to that. So they put that in a nugget, a piece of information that you can go along with. You can download it and put it on your phone, or you can join us right here on the show and we discuss that. We're talking about the nugget for this week, and we have taken it from paragraph E-ECP 3.1, paragraph A, paragraph I, and II of the Appendix FM to the immigration rules. And what does it say? It says that an applicant for entry clearance as a spouse can rely on savings to prove his or her finance where he or she does not have sufficient income from employment or self-employment. To rely on savings, the amount should be specified savings of £16,000 and additional savings of an amount equivalent to 2.5 times the amount, which is the difference between the gross annual income of 29,000 and the actual income the applicant or the sponsor receives. That is 16,000 plus that is 29,000. That is the actual gross wages. Now, this seems a little complex. It's got some calculations here and there. So we will be putting that to Lawyer Charles Asma for him to help us do that. And just before I bring on Lawyer Charles Asma, let me do some housekeeping and say thank you to those of you who have joined us. I want to say that we are live at BWF Solicitors both on Facebook and YouTube, and at BWTV both on Facebook and YouTube. What I want you to do when you join us, please announce your presence and also indicate that you are here. Let's pick up a few and say welcome to them. Stephen Boache Holland, you're saying hi. You joined us on Facebook. Thank you so very much, Stephen. We next have James also saying hi to us. Thank you, James, for joining us. James Anto, you also said hi. Thank you very much for joining us. Ade Safo, good afternoon, everyone, he says, and thank you very much, Ade, for always being around and making sure that everybody feels welcome and comfortable when it is that they join us on the show. Now, this afternoon, when you have a question and you want to put it to Lawyer Charles Asma, I want to say you can text 07399 208 468, 07399 208 468, or you can send it to the comment section down below. And the number is, okay, I've given you the WhatsApp number in the comment section down below, either on Facebook or YouTube. And when the lines are active, you can reach us on 0208 493 7345. The studio number is 0208 493 7345. When the lines are active, yes, we will give you the opportunity to speak to our resource person and a guest, Lawyer Charles Asma. Lawyer Charles Asma will be joining us in a minute, but I want you to also remember that you can join us both on Facebook and YouTube. Alex is on YouTube. Thank you, Alex, for that contribution. We have this piece of announcement to give you. It's with a heavy heart that we announce that our partner and a lawyer of BWF Solicitors, Lawyer EUSS, has lost her mother. Mrs. Helena Tutua Akumi has been called to glory, and we are mourning with our dear partner. The details for the funeral will be announced shortly, but I want to give you the hint that Wednesday, 25th of March, 2026, Trinity Baptist Church, West Norwood, as well, we have the funeral service. Then we will move to do the burial service at Croydon Cemetery, and then the reception will follow. Further details will be given you. We'll have our Sunday Thanksgiving service that weekend at Barking Baptist Church in East London. Further details, as I said, as we continue, we will be giving you that. So, as I said, it's with a heavy heart that we announce the death of the mother of Lawyer EUSS Achampong. Mrs. Helena Tutu Akumi has been called to glory. Condolences to the family, and I believe that those of you who have contact with her would call her and console her as well. Lawyer EUSS, our hearts are with you. Condolences to you and the family. We will quickly take a break, and when we come back, we get into the discussion. It's the community and the law. Remember the nugget I've given you when we have had the explanation. We will be looking at a scenario where it is that I will ask you to give me some possible correct answers. It's the community and the law. I'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back and thank you for sticking around. As I mentioned this afternoon, we're going to a very interesting discussion where we're looking at EUSS applications that are being refused. The question we are asking is, why are they being refused? And what solutions could there be? I have the honor and pleasure of introducing a resource person and guest from the stables of BWF Solicitors, Lawyer Charles Asma. Uncle Charles, good afternoon.
Hello,
Yes,
good
sir. Good
afternoon.
afternoon. How are you?
Good afternoon. Very well. How are you?
I'm doing well. By God's grace, we are here smiling and bubbly for the community.
Yes, so community activities have taken us to Hall. So we are reaching you all the way from Hall.
Okay, well, that's brilliant. I believe that we will have the opportunity sometimes going into the community and doing the live from there so people will have a
Exactly.
feel of what it is we do in the studio, isn't it?
Fantastic. Yes.
Right, right. Well, we thank you so much. Obviously, as you said, community activities is taking you far away from us, but you have rightly and graciously so joined us to have that empowerment we give to the community on. Uh, I will maybe give you the opportunity to say your hellos, but there's this question that I would want to pose about the entry clearance situation for spouses. And we're saying that people can rely on savings, and the amount should be a specified savings of 16,000, an additional savings of an amount equivalent to 2.5 times the amount, which is the difference between the gross annual income of 29,000 and the actual income the applicant or the sponsor receives. When it comes to mathematics, some of us are not very comfortable. So we would want you to help us unpick this one and get a better understanding of that. So yeah, you say your greetings and somebody will say, I'll push you with this one.
Right. Viewers and listeners, thank you so much and a very good afternoon to everybody, wherever you are reaching us from. Today's conversation or this afternoon's conversation is crucial. because most people will not have employment income. Most people will not have self-employment income, but would want to sponsor their spouses to join them in the UK or to remain with them in the UK. However, they can show that they have savings. So if I have savings, can I use it to show maintenance or finance for my spouse application? If yes, how much? That is the conversation. That is the key aspect of the nugget. The nugget is just saying that if somebody does not meet the requirement for finance of 29,000, but they have savings, what can they do?
Mm-hmm.
The rule has specified a formula, and it is the formula that the nugget is given so that anybody who wants to rely on savings can apply the formula to decide or determine how much savings they need to have. So, under the rule, it says that you must have the basic savings of 16,000, the basic savings,
Mm-hmm.
and the additional savings. The additional savings is the salary you earn. You
Okay.
take that salary you earn from the salary you are required to have. The salary you are required to have is 29,000, right?
Yes.
So if you are not working and you are not earning, then your salary is zero.
Okay.
So 29,000 minus zero is still 29,000.
Mm-hmm.
Then you multiply the 29,000 by 2.5, which is 29,000 times 2 times half. You add to the 16,000, and that will give you how much savings you must have if you want to rely on savings. What it means is that if you are working and not earning enough, you
Mm-hmm.
can still rely on your savings. And so, for the purposes of this conversation, Brakuku, what I want us to do is to spend about 3 minutes to test the formula. Do you have
Okay.
your calculator there, Brakuku?
Yes. So we
Can
have.
we go side? Can we go side by side? Yes, good. So
Okay.
we know the formula. The formula is 16,000
Mm-hmm.
plus 29,000 minus the money the person is earning from income or
So
from salary
29,000.
from employment. So
So
let's give example.
16,000 plus 29,000.
So no. So 16,000 plus two, and don't use the calculator yet because we
Okay.
haven't come up with facts yet. So
Mm-hmm.
for now, the formula is 16,000
Mm-hmm.
plus 2.5 of 29,000 minus your own salary a year. So
I
let's
think
give
I think
example.
that for me that's where the confusion is, because
Good.
you say I should have 16,000 in savings. I was
Plus.
supposed to have been earning 29,000 per year, but
Yes.
I don't have it. I don't earn that
Yes.
much.
Yes.
The
Then you must
natural
have more
understanding
than,
people will
then
have.
you have more, in this case, you must have more than 29,000 to show
Okay.
to prove as savings.
Okay.
So let's take example. We're going to have 3 examples. So
Mm-hmm.
you want to sponsor me.
Mm-hmm.
I'm your partner. You want to sponsor me. On this
Yeah.
occasion, I am I am Mary, not Charles. I am Mary. So you
Mm-hmm.
want to sponsor your partner, Mary.
Mm-hmm.
I work or you work, but because you
Okay.
are sponsoring me, I'm coming from abroad. So my money is in local currency. I don't have enough. But you work and you work part-time.
Okay.
Or you work or you don't work at all. So let's assume you don't work. If you don't work,
So
then
your
the
income is
salary
zero.
will be zero. So 29,000 minus zero, what do you get?
29,000.
Multiply by 2.5. This is where you use the calculator.
Okay. So
So 29 minus zero
20, hold on, let me 29,000
minus
minus
zero
0 is 29,000
times 2.5,
times
2.5
2.5,
equals to
72,500
plus 16,000.
plus 16,000,
What do you get?
88,500.
So somebody who doesn't work at all, both part sponsor and applicant don't work at all. their savings must be 88,500.
Where are you going to get this money from?
Well, that is what you pay if you don't work. So that's one. Let's
Okay.
assume that this time you work, but you work part-time. So it's not up to 29,000.
Okay.
So let's say you work and you earn 15,000 a year. 15,000.
15,000.
So 29 minus 15, isn't it?
Yes.
What do you
So
get?
that's 14,000.
And times 2.5,
14,000.
which is 28 plus 7,
14,000
which is 35,
times
right?
2.5 is 35,000.
35 plus 16, which is the standard savings.
Plus 16,000.
What do you get?
51,000.
So somebody who works part-time earns 15,000 a year will have to prove savings of how much?
51,000.
51,000. So you can see that if you are working, the savings will come down. If you are not working, the savings is high. Let's
Okay.
assume somebody called me last time to say that, lawyer, I want to sponsor my partner, but my employment income is 24,000 a year. It's not up to 29,000. What do we do? How much savings? How much savings will this person need?
So
So 29
29,000
minus 24
minus 24,000, 5,000 times 2.5, 12,500
plus 16.
plus 16,000. So 28,500 savings you have to prove.
No,
Or
try
you have to
again.
prove that you have
No,
income or
try
resources
again.
up to
No,
28,000.
how much did you get? 28,000.
28,500
Good. Because the person is working and earning almost 29,000, the savings threshold will come down.
will come down. Okay.
Because somebody will say, but the person needs 29,000. So why would they go for savings of 28? Because their actual salary is not up to 29,000.
Mm-hmm.
And what it means is that with that savings of 28,000 and their salary of 24,000, they can still cope
Okay.
once the person joins
Once the
you.
person comes in.
Exactly.
Right.
So that is
Okay.
how. So if you look at three examples of how the formula for savings is applied, and therefore the rule says that under paragraph ECP, ECP is the eligibility criteria for entry clearance as a partner.
Okay.
3.1, 3.1A, there's I and II. It says that if you are relying on your savings, A says that you must have 16,000. And so A says that if you want to rely on your savings of 16,000, you must also have other additional saving. And the other additional saving is specified under II, which is 2.5 of the actual 29,000 minus the actual money you earn a year.
Okay.
So you add II and I will give you the actual savings required for immigration purposes as a spouse if you don't have 29,000 salary.
Okay, Laura, let me look at this scenario and see what advice we could give to our friend. Our friend is Sanusi. Now, Sanusi intends to make an application for a visa to join his wife, Amma, who has indefinite leave to remain in the UK. Amma works part-time, Laura, and earns 12,000 gross per year. Sanusi is unemployed but has savings income that he wants to rely on for his application since his wife's income does not meet the 29,000 salary needed for his visa application. Um, how much savings should Sanusi have in his bank account to make his application possible? I have got four answers. I will ask you to I will ask you to tell me now. Let me see if my friends and my viewers would be able to follow the formula as you took me through. How much savings should Sanusi have in his bank account to make his application possible? Would it be 58,000? Would it be 58,500? Would it be 16,000? Or would it be 29,000? So look at it properly. Amber works part time and earns 12,000 gross per year. That is before tax is taken. Okay. Sanusi is not employed, but he has income that he wants to rely on for this application, since his wife does not meet that 29,000 salary threshold. So savings that Sanusi should be one of these four as you have on your screen. Think about that. Remember what lawyer Charles Asma took us through when I picked up my calculator and did the calculation. And let's see what answer you have. Remember, an applicant for entry clearance as a spouse can rely on savings to prove his or her finance where he or she does not have sufficient income from employment or self-employment. And the paragraph EECP 3.1A, 1 and 2 of the Appendix FM of the Immigration Rule says that if you want to rely on savings, the amount should be a specified savings of 16,000 and additional savings of an amount equivalent to 2.5 times the amount, which is the difference between the gross annual income of 29,000 and the actual income the applicant or the sponsor receives. That is 16,000 plus 29,000 minus the actual gross annual wages. I'll get you thinking, isn't it? We'll come back to it. Lasma, thank you very much for coming on board. Ladies and gentlemen, if you are with us, we're live on BWTV and at BWF Solicitors both on Facebook and YouTube, and BWTV both on Facebook and YouTube. Kojo Citizen, thank you very much for joining us. Good day, everyone. Thank you so much. Those of you who have joined us and you have not mentioned your presence, please do that. Eben TV GH, thank you very much. Great submission, my brother. And also to we have Rama Nana Sewa. Rama, thank you very much. Now there's this thing that I've seen going on, and let me sound this caution. People are trying to be smart, but it's foolishly smart. They are trying to use the platforms that genuine solicitors and lawyers use on social media to dupe people. Listen, when you try to use BWTV, BWF solicitors, you'll be found out. And when we expose you, one, your fake account will be blocked and we can pursue you. So be careful. People have put their reputation and their integrity on the line to properly educate people, invested with your time and money and all that. And those of you who are trying to be mischievous, be careful. We'll find you out and we'll pursue you. We'll be right back after this.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Welcome back, and thank you for still staying with us and following us on our various social media platform. Remember, the lines are active, and we're doing this courtesy BWF Solicitors. You can call us when the discussion is finished on 0208 493 7345. You can send a text, WhatsApp, or voice note to 07399 208 468. BWF solicitors, our numbers are 0208 493 7340. Those of you in Ghana, you can visit the Ghana office 055 589 5959. And in all situations, emergency situations, really, you can call 077 127 61884. Now, let's get into our discussion this afternoon. We have rattled our brain a bit with those calculations, but it's quite easy and straightforward. But let's look at why EUSS applications are getting refused. Is there any solution to that? Keep your questions coming through. You can text those ones as well. But please, let's sit back and ask Lawyer Charles Asma to tell us if the reasons are found and obviously what the solutions would be. Lawyer Asma, EUSS applications. People have the pre-settlement and the settlement status. Pre-settlement, people go in for the further leave to remain, and those applications are being refused. EUSS in itself, why are they being refused? What's happening?
Thank you very much, Brakuku. Thank you. Yeah, so we are looking at EUSS applications. That is the EU settlement scheme applications for EU nationals or EU family members.
Right.
We know that we are in 2026 and that Brexit occurred on 31st of December 2020, 11 p.m. That is Brexit date.
Yeah.
Since Brexit, from the 1st of January 2021, anybody who was to make an application for leave to remain in the UK as a national of EU or as a family member of EU, one should have been in the UK before the date and also should have been a family member of that EU national before the date. So if somebody is making EU application today, the person should show that first they were family members of that EU national before 1st of January 2021. That's important. Again, if you're an EU national and you want to apply to remain in the UK under EU rules, the withdrawal agreement of 2020, then you have to show that you were resident in the UK before 1st of January 2021. That is also important.
Okay.
Then the government said that most people genuinely wanted to make application, but some factors were beyond control. And so they couldn't make the application by the deadline.
Okay.
So they extended the deadline. We are talking about in-country applications. In-country applications.
Okay.
Out-of-country applications are still on valid in country because we are saying in-country EU applications. So this person, I mean, the law, the new, the amnesty or the provision was extended. The deadline was extended to to say that from June 2021, if you have not still applied before, you have up to that date to apply.
Mm-hmm.
So it was extended by more or less 6 months. Then it was extended again to August 2022 thereabout. And from that date, they said that anybody who wanted to make an EUSS application in country should have done it.
Mm-hmm.
And so if you still haven't done it, mind you, we are now going into rights and breaches of rights.
Okay.
Under the T agreement, EU nationals cannot be denied their rights. So if you introduce a law to say that you can't do this, you can't do that after the Brexit, then you have to be flexible. So the government now said that anybody who still has not applied, you can still go ahead and apply, but you must give a reason why you are still late. That's a
Okay.
fair request, isn't it?
Yeah, obviously, yeah. If you are late, there must be a reason. Yeah.
A reason. And therefore, they introduced a provision called reasonable grounds for lateness.
Mm-hmm.
And that reasonable grounds for lateness should explain why up to today, 2026, or up to last year, 2025, or up to before 2024, you had not still made an application under EUSS. And because we are in 2026, we say up to today, and why people are still getting refused, and what are the solutions for that. So the first reason why somebody may be refused is that the person couldn't explain why they were late. And for those people, the application is likely to be considered invalid. And
Okay.
once the application is invalid, there's nothing you can do, and you do not also have right of appeal because there's no application to be decided because you couldn't meet the validity requirement for an application. So one of the validity requirement is if you are late, explanation as to why you are late. If the explanation is not reasonable, then you will be you'll be told that the application is not valid. What is reasonable excuse or delay? One,
Mhm.
you've been unwell for all these years. You are
From
now
2020 up to date.
today, and
Mm-hmm.
you are now fit to go ahead and do what you should have done. And therefore, so if it is on health grounds
Mm-hmm.
and it is not your fault, then
Mm-hmm.
somebody must vouch for. Who is going to vouch for you if it is on health grounds? Brakweku, who will vouch for you if it is health?
First of all, your doctor or GP.
Good. So you need a medical report to confirm that indeed you've been unwell and this is why you couldn't do it. So if you can't provide evidence of sickness or illness, then you cannot use illness or sickness as an excuse.
Mm-hmm.
Point one. Point two, why somebody will say that they want to make an application even though they are late is that potentially the person was in prison.
Okay.
And if you are in prison, you are incarcerated, and so you don't have any freedom to act. And that is why. So if you claim you were in prison, what do you have to show?
A
Maybe
report
prison
from the prison.
maybe prison certificate, but they don't issue certificate. They don't issue certificate. So evidence that you were in prison indeed, there will be paperwork. That's
Mm.
one.
Right.
Number so the other so we are mentioning the fact and the evidence.
Evidence. Yeah.
Let's go to the third fact, which will be a reasonable excuse. There are some people who work on the sea, seamen. Some will go on sea for years, months, weeks before they return. And if
Mhm.
you've been indeed at the time you were supposed to do it, you've been all over the world cruising because of the nature of your work, and you have just returned from deep sea, then that would be a reasonable excuse for not
Mm.
doing it. What do you have to provide?
Your the evidence that you have been working.
Evidence shows whatever you have to show that indeed that is the
Indeed, you
case.
were at sea.
Bring it.
But
There you
Laura,
go.
interestingly, um, maybe I'm preempting the question and I'm jumping the gun, but let me put it this way. I, the deadline was the 31st of December 2020, end of June 2021, the following year, August, and all that. When I'm proving that I am late, where do I start from? Is it from the original deadline or the last date of the extended and the probation, the grace period, so to speak?
So this is the job for the person. Let's take example. And here
Mhm,
there's logic to this. This is not law. It's logic and more of common sense here. For
mhm,
example, you are giving me evidence that covers 2024 and up to today
mhm,
to say that this is why you didn't do it in 2024, 2025, and now in 2026 you are doing it. What
mhm,
are you trying to tell me? You are trying to tell me that what you have is from 2024. That means you don't have anything for 2023, 2022, 2021, right?
mhm.
That means you were available. Why didn't you do it before you traveled, before whatever happened to you?
Yeah, that makes it quite tricky and difficult, really, because
That's what I'm saying. It's up to you. It's up
it's
to the
up to you
person
to
to
prove
sit
it.
down and say,
Yes.
"Well, it's been about 6, 7 years. Why haven't you done it?" So if you're going to tell me that you've been away, you've been unwell, you've been in prison, all these things are happening, then you must prove from that point, not just recent.
Okay.
Yeah, because recent will then give you away.
Mm.
But if it's historical, that will make sense that that is why all these years
You
you
have
haven't
not
been
been able
able
to do
to
that.
until now. So we've
Now,
mentioned
what
three
if I
reasons.
say I was at sea at that time? Probably I have not properly followed news. And between that period to where the grace period ended, I may not have heard it, but I've now I had the information that I needed to do that. Would ignorance be accepted?
So it depends on whether it's legitimate ignorance.
Mhm,
So if we are going to legitimatize the ignorance or make the ignorance legitimate, then
mhm,
somebody who's been at sea for 5 years, 3 years, they've just returned. Then we have to look at a person's circumstances. This person literate or illiterate?
mhm.
If you are illiterate, potentially you watch the news, but you don't even understand what is happening. You don't have friends, you don't have anybody. If that is the case, fine. But can you prove that? It's difficult to prove.
Yeah.
And on that basis, we may just ignore, but then it's up to the caseworker to read the storyline and make sense or meaning out of it and say that on the balance of probabilities, I accept it.
Okay.
Yeah. So that would be a discretion for the caseworker.
Okay.
Yeah. Then we go to the fourth potential reason.
Yeah.
Well, there are some people who depend on their parents. So I'm a child. I depend on my parent. My
Mhm,
parent was supposed to sponsor my application or do it for me, right?
mhm.
Because of my behavior, because of the relationship with my parent, the relationship is so bad that they decided not to help me out. Friends came in, family came in, the church came in. Then after 5, 6 years, my mom or dad or my stepmom or my stepdad said that that's fine, no problem. I will leave it to God. Now I've accepted you back. So now they are ready to sponsor you. Could that be an excuse? Potentially.
Well, discretion maybe because what proves that you had issues with your parent? Would you
And that
now
means
have letters from the people who mitigated and mediated between the two of you and all that? Would those be enough evidence?
very good. That is why we have to have verifiable source to support to corroborate the claim from you, your parents, that indeed this was happening all these years, and it took the intervention of these stakeholders to
Mhm.
resolve the matter. and these are the things they did on paper.
Okay.
The
All
next
right.
one,
Would there also be, I know you're going to the next one, but that parental bed. So what if Kwasimenu didn't know that Ataya was his daughter and he's now found out? Would that be an excuse? A good one, so to speak.
if you say he Kwesime didn't like, so there was dispute as to paternity or maternity.
Yes, possibly.
If that's the case, was it contentious and was it being resolved in court? If so,
Well,
we'll need court papers.
hmm,
And if that is the case, so be it.
okay,
That's that is on the balance of probabilities, plausible evidence that you couldn't have done it at the time.
okay, all right,
Right. So we've mentioned all these. The other bit potentially could be somebody who is a spouse, and the spouse was supposed to um, help you put in the application. But again, due to misunderstanding on and off, I love you, I don't love you, I love you, I don't love you, I accept you, I don't accept you, go back, come again, all these things. The person didn't want to do it. But then it's been resolved back to life.
hmm,
Now the person is sponsoring your application. So again, we have to look at the mediation processes to be able
okay,
to support the claim that there was something that prevented this person to put in the application.
okay,
But you cannot say that you cannot read and write. That's why you couldn't type. You can't say that was IT problem for 5 years.
ah,
You can't say that you didn't know. You should have sought legal advice.
yeah,
So there are things that will be accepted and things that will not be accepted. And things that will not be accepted are things that may come from you.
okay,
Because you cannot benefit from your own inefficiency or deficiency. But
deficiency,
if the deficiency is act of God, like sickness, like death, like those things, then you cannot be punished for them. And that is why you take advantage.
yeah. Now, when the evidence is presented to the caseworker, do they have to use their discretion, or there may be some criteria that will be set out for them to use to judge the evidence they have?
So the whole game hinges on evidence.
Okay,
They have said that bring your reason and support it with evidence. So if you have a reason and you have evidence that is verifiable, then I have met my part of the obligation.
okay,
The second part, which is the duty, will be on the caseworker to test my evidence.
evidence.
So if you're going to test my evidence, you can go ahead and verify from the sources that I am providing to you if you want to.
Okay,
So if I brought you medical report and you don't believe it, you can go behind me and find out. If I brought you church mediation report and you don't believe it, you can go behind me to the church and verify.
hmm,
But if you are going to waste money and time in your attempt to verify, then on a balance of probabilities, you can have your framework of analysis
okay,
and conclude that I believe that this is satisfactory evidence.
right,
That's why they say that on I am not satisfied that, they usually say I am not satisfied. So if they are satisfied, then they will just go ahead and you agree.
and
If they
right,
are not satisfied, that means the evidence is weak. So it's your job to make sure that the evidence is strong enough to support the claim.
right.
Right.
So if they are not satisfied, do they give you the chance to give them further evidence, or they can just go ahead and say, because I'm not satisfied, I have refused?
Remember, this is just to confirm whether the application is valid or not before
Or
it goes
not?
to the next stage.
Okay,
If the application is valid and it goes to the next stage, the person will be issued with certificate of application.
okay,
So if you don't get certificate of application after some time, then you would have received a letter that the application was not valid because there was no reasonable grounds for lateness supported by evidence.
Okay. So if you just joined us, we're looking at the situation where EUSS applications are refused, and Laura is giving us the scenarios and, of course, the kind of build up before that decision is made by the social worker to say that your application is not valid and that it will be refused. One of them is lateness in applying. And if you are late in applying, considering that the EUSS deadline has been passed, we've gone past the first grace period, we've gone past the second grace period, and you still have not done it. Between 2020 and 2026, that's more than 5 years, and you still have not done it. There must be some very good reason as to why you were not able to do that. In some quickly, we said maybe an act of God, disease, or whatever. You were out of the jurisdiction, or you were out of town. Say, for instance, you were a sailor and you've been at sea for 5 years or more. Situations where there were possible disputes between yourself and your family member, and it has now more or less been resolved. And then also some situations that you would have to explain. Now, your explanation should be very cogent, reasonable, and acceptable. And as we always say, evidence is the name of the game. Um, Delay and some of these situations, could there be any other reasons or excuses that people could give apart from what you have given us, lawyer?
All right, yes. So we've looked at validity as one of the reasons why people's EUSS application fail. The next factor that cause failure when it comes to EUSS application
Mm-hmm.
is the threshold or the requirement itself. So I'm going to take you to the requirement framework. There are two sets to the EUSS application. We have one under paragraph EU 14 to the appendix EU to the immigration rules, which is to do with pre-settled status application.
Mm-hmm.
And there's another one that come under paragraph EU 11 of appendix EU to the immigration rules. That is for indefinite leave to remain application or settled status application. For EU, for EU, for 14, which is pre-settled, of course, you are going to be given 5 years. But you have to show that you have been resident in the UK prior to the time of your application, especially at the time you were making the application if you are in the UK.
Mm-hmm.
And again, you are looking at relationship. So residence, relationship, and depending on your circumstance, dependency. So relationship here is either you are applying as a child, or
Mm-hmm.
you are applying as a parent, or you are applying as a spouse, isn't it?
Yes.
We know that from 31st of December 2020, or should I say from 1st of January 2021, you cannot apply under EUSS for extended family because that is gone. So this conversation is for nuclear family members, nuclear family, direct.
Mm-hmm.
So parents, spouses, children. As a spouse, you need to show that this is your spouse, and that is relationship. So marriage certificate, right? Marriage certificate. So
Mm-hmm.
with your marriage certificate, you can confirm that this is your spouse.
Okay.
Question. To be able to apply under EU, Appendix EU, you should have been a family member of this sponsor before the end of
December
December
2020.
2020. So if you claim you married before 1st of January 2020, um,
21.
2021, again, why didn't you apply before that? But again, for some the reasons we've mentioned, you couldn't. So you've been able to prove that you were married. So the marriage certificate date should show before 1st of January 2021. If it doesn't, then your application cannot go under EU. It has to go under standard immigration rules. So that's one. The other one is you are going as a parent. So again, birth certificate. You have to show that this is your child and that child was your child before the deadline. And so you've established the relationship. And if you are going as a child, you show that this was my parent and this was a parent before the deadline. So if I establish the three areas of relationship,
Mhm.
and we move on, of course, if it's a step parent, the same relationship category. Then we move to dependency. If you are a child and you are applying and you are over 21, you are 21 or over, then you have to show dependency. And with dependency, you have to show that your parent or the sponsor is the one who looks after you in terms of your essential living needs.
Okay.
Essential living needs, we are talking about food, clothing, shelter.
Shelter.
These are tangible aspects:
Mhm.
clothing, shelter, and food, tangible. There are also intangible support, such as guidance and support, counseling. And so here we are looking at material, financial, physical dependency. And we're also looking at emotional, psychological dependency. And you can rely on any of them, but the
Okay.
more, the better.
Okay.
Right. If the person is a child under 21, then they don't have to show dependency. Again, if this is your parent, you don't have to show dependency because a natural person with common sense will look after their parent. So you don't have to prove it.
Okay.
But if you are applying for your mother-in-law, in other words, parent-in-law, then you have to show dependency.
Mhm.
That's the difference.
Let me ask about this situation. There is a child that is 15 years now, less than 21, and been giving the notice that they could apply for their indefinite, and if they are not able to do that, they have 5 years to make that decision. Now, this child who is 15 years or less than 21 years, do they have to show dependency on their parents?
The child is how old?
15 years or less than 21.
No, under 21, you don't have to.
You can just put in the application and they'll look at it.
Yes, because ordinarily, a good parent will be looking after their children under 21.
Okay.
Under standard immigration rules, a child is under 18. But under EU rules, a child is under 21. It's funny, but that is the benefit EU nationals and their family members have under the treaty agreement and the withdrawal agreement.
Okay. All right. So when you have a situation like that and you are above 21, then definitely you would have to give evidence that you depend on these people, and that should be at least the basic food, clothing, and shelter. Is that correct?
And in addition to that, emotional, psychological support, information, guidance, and counseling support. For example, I am 25. However,
Mhm.
I still depend on my father to support me in terms of career guidance, support, career choices,
Mhm.
even sort of relationship to go into. My father uses his past to support me and to guide me. Without him, I will be wayward and I will be making silly choices and decisions. Then you depend on the person.
Okay. But
Whenever, whenever I am, whenever
you,
I am
you, you,
troubled,
you always say something, the more the better.
the more the better.
The more evidence you have, the better, isn't it?
Yes.
Okay. Well, folks, if you just joined us, the discussion is going into a very exciting bit of it. We are going to really look at the refusal of these applications. And the second part of the question is there a solution? I believe there is. And if you have just joined us, listen, you haven't lost much, even though you've lost the initial discussion, you haven't lost much because we're going into the meaty part of the whole discussions. What we are discussing is why our EU applications getting refused and what is the solution. Don't go anywhere. We'll be right back.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Well, as I mentioned, we get into the meaty part of the whole thing. And the second part of the topic is there a solution? Why are EUSS applications getting refused? Lawyer Charles Asma is here with us from BWF Solicitors. BWF Solicitors are trusted partners when it comes to the law. You see what they put their efforts in to help us understand these things and empower us as members of the community. Lawyer Asma, we are looking at why the EUSS applications are being refused. What can we do? Is there a solution?
Yes, of course. Now, before we go into the solution, can
Mhm.
we quickly add a couple of things that have
Yeah,
become
sure.
a
Sure.
bane in this whole EUSS application enterprise? Let me quickly touch up on retention of rights.
Okay.
Most people apply for retention of rights. That is, apply under retention of rights, making application for settled status, even though they haven't done 5 years on the pre-settled status. If you do that, the application for settled status will be refused because you haven't already done 5 years. The fact that you have lost your partner or the fact that your relationship is over does not mean that you can apply for indefinite. You wait. Once your 5 years is about to expire, you apply for the indefinite. So that's really important because most people will apply for settled status and they will refuse them and tell them that you haven't lived in the UK or you have not been in that relationship for 5 years and therefore you cannot apply for indefinite. So let's bear that in mind.
Mm.
Retention of right is not an application on its own. It's a basis for an application. And you only make that application for settled status based on your retention of right once your 5 years pre-settled is due to expire.
Okay.
Now, again, some people will apply for EUSS application relying on retention of right, but they are not able to prove it. For example, you claim that your wife or your parent is dead, but you don't have the death certificate. How can you prove it?
Mm.
Your parent that brought you to the UK, or your wife that brought you to the UK, or your husband that brought you to the UK, or the family member that brought you to the UK, the EU family member, is dead. But you claim that you are a family member, yet you don't have access to the death certificate. How do you prove your case for retention of right? Because retention of right means that something has happened, and therefore the sponsor is no longer there.
Mm-hmm.
So let's bear in mind. The other reason why most people get refused is that at the time they are making the application, they cannot prove that the EU national, him or herself, has EUSS residence permit.
Yeah.
So if the EU national hasn't done what you want to do, how can they sponsor you?
Because that you have.
They must be relevant sponsor. In other words, the person should have done the EUSS application themselves and granted. And you need the person's EUSS application reference number.
Okay.
In the past, because the person will say they don't remember the number of the sponsor's application reference,
Mm-hmm.
they will put anything there up to 16 digits, and the system will allow. Then the system will go through the system itself to pick out the EU sponsor's number if they have already done it.
Okay.
This time, you have to provide. So if you don't provide it, you cannot even progress through the application process. So let's bear in mind. Somebody will come, lawyer, I don't know. My sponsor, I don't know. I don't have a copy of the EU letter, a USS letter. I don't have the reference number. If you don't have it, then you cannot, it's difficult to progress in your own
Mm.
application. So let's be mindful. The next thing is people will be making application currently, and they claim that this is a family member, and they have birth certificate to show. This
Mm-hmm.
person came to the UK last year, for example, as a student or as a skilled worker or as anything, or even visitor. Then they want to apply to remain in the UK based on their grandmother, grandfather, or their parent.
Mm-hmm.
When they were coming from abroad, they made application. On that application form, the question was, do you have anybody in the UK? Do you know anybody in the UK? Do you know what the person would have said? They will say no, isn't it? Normally.
Yeah.
But you don't want them to know that you have somebody so that they will think
Somebody
that
in
if you
the
go,
UK.
you won't
Yeah.
come. So you say, no, 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 me, I don't know anybody. Oh, okay, that's fine. No. You came in last year. This year you want to make application only to tell the caseworker that, oh, I know somebody, and this person is an EU national, and this person is my grandmother, grandfather. Does that make sense?
No. Maybe you forgot.
Really? Somebody who looks after you, because you
uh,
must show dependency. Who looks after, and now you say that, oh, this person has been looking after me when I was away, when I was in university in my country, the person was sending me
could,
money. And when
could
you were
I also
coming,
say that I didn't understand questions, so I said no?
but if you don't understand the question, you don't answer because there are two answers, yes or no.
Or no?
So if you
But
didn't
some
understand,
online applications learn. Some online applications, when you don't answer the preceding question, you can move on to the next one.
so then let me ask you a question.
Uh-huh.
If you didn't understand the question, why didn't you say yes? Because yes is also an answer.
Well, mini, money, more.
Okay, if it's mini manimo, then you take the blame. Right.
Anyway.
And so there are a lot of instances where you even go into further analysis. And you know the age difference between the grandmother and the mother of this person? The difference
Mhm.
sometimes is 10 years.
Okay.
The difference sometimes is 13 years.
How can you be
The
a
difference
grandmother?
sometimes is 5 years. So you are saying that the difference between your mother and your grandmother is 5 years. So your mother was born when your grandmother was 5 years.
It doesn't make
Which,
sense.
which
It's not logical.
biological which biological theory support this claim?
Mm-hmm.
So caseworker will know that you see is one of those things. Then obvious refusal, isn't it?
Yeah.
On the basis that the caseworker is not satisfied that there is a genuine relationship between the applicant and the sponsor.
And the sponsor. Yeah.
Right.
Okay.
So all these things are important. Again, somebody will come in, they want to make application in 2026 on the basis of their EU sponsor. They've been in the UK for 2 years. They don't live with the sponsor. They haven't received any support from the sponsor. And out of the blue, the sponsor is going to sponsor them. Will the person be granted? No.
No.
So these are the basic things we do that call for refusal.
Mm-hmm.
And some things like this, when you are refused and you go to court, the judge cannot turn things around because you messed it up from the beginning.
From the beginning, yeah.
If the age difference is 5 years and they tell you to go and fight in court, and you go to court and tell the judge that, look, this is me. My mother is now 40 years. Or let's say my mother is now 50 years, and my
Mm-hmm.
grandmother is 60 years, and my grandmother is EU. And you tell the judge will ask, really? Between your grandmother and your mother is 10 years difference. Hmm. You see. So you even lose in court with this argument.
Oh, yeah.
So we've picked up on all these aspects. We've looked at why the application could be invalid. We've looked at what you can do to make it valid. We've looked at why you are refused under retention. We've looked at why you are refused under relationship. We've looked at why you are refused under dependency. And we've looked at why you are refused on the basis of flimsy points that the person is my family member, even though you claimed last year that you don't have any family member in the UK.
Mm.
Now, solution. The
Yeah, that's the most interesting part of the whole thing. Is there a solution?
Yes. So anytime you intend to make an application under EUSS,
Mm-hmm.
within the framework, there are a lot of options. So if you are applying, you ask yourself, on what basis am I applying? If you're
Mm-hmm.
applying as a child, is this family member a grandparent or a parent? If this family member is a parent, you have to check whether you depend on them or you don't depend on them. If you don't have dependency evidence, then your age should not be 21 plus. But if your age is 21 plus, then you have to show dependency on your sponsor. The next thing is that you have to check whether this EU national themselves have already enrolled onto the EUSS scheme. In other words, they have pre-settled or settled status. If
Mm-hmm.
they haven't done it, then it's difficult. The next thing is the EU family member, is the EU national person resident in the UK? Some would have come to the UK, but they don't live in the UK anymore. Can they sponsor you if they don't live in the UK? No. How do you prove that they live in the UK? Ordinarily, you are going to use proof of address, residence evidence, but you're also able to check through the airport files, the movement at the airport, whether the person has been out of the UK, how many times, and they can conclude that from the evidence available, it is possible they don't live in the UK. So we
Mm.
will have to be mindful of that.
Okay.
You are applying on the basis of your retention because your family member spouse has died or the relationship is broken down. If the relationship is broken down, it means you were given 5 years based on the relationship. So, Brakweku, let's take note of this.
Mm-hmm.
2021, this person was given 5 years.
Yeah.
22, 23, 24, 25, 26.
26.
2026, the person is going to apply for indefinite leave
In
to
the
remain based on the fact that they've lived in the UK for 5 years after marriage to their EU national.
Yeah.
Then 2023, they claim that the relationship broke down and they have divorce certificate. You are going to apply. If this person was still in your life, you would need evidence to show that you live with the person.
Yeah.
But because the person is no longer in your life, you don't have to show evidence because they are no longer with you. Question: from when are you going to say they've not been with you? Is it the whole 5 years or some of the 5 years?
Some of the 5 years, because evidently the relationship broke down in the middle of your 5 year period, isn't it?
Fantastic. If it is some of the 5 years, that means you should be able to prove some of the 5 years.
Mm-hmm.
So you have to show between date of marriage and the date you got your and the date the divorce came.
Mm-hmm.
From date of marriage, you started living with the person. And from this date to the date of divorce, you were granted pre-settled status, or you've had pre-settled status. Let's say this gap is 3 years,
Okay.
and the remaining gap is 2 years.
2 years.
So the 2 years is after the divorce. So with the 2 years, you don't have to provide evidence from your sponsor because you don't know the
You
person
don't know,
anymore.
yeah, they're no more in your life.
And therefore, commonsensically or logically, you cannot be asked to provide evidence that you live with a person because you don't live with a person. So how do you show that you don't live with a person? The divorce, isn't it?
That's right.
So
Yeah.
the divorce will fill this gap. But what about the gap before divorce? Were
You
you
should
living
be
with
able to provide
were you,
evidence for
were
that.
you living with a person before divorce?
Mhm.
If yes,
If
you
yes,
have to
yeah,
prove. And you can't say no because through your relationship and living with the person, you were given
you were
pre-settled.
giving the pre-settled status, yes.
So you can't say that you are not living with the person for 5 years.
Mm-hmm.
And so you have to prove the part you were living with the person and the part you were not living with the person, you don't have to prove. So if you come to me to make an application and you claim that you don't have anything from the beginning to now, then you are telling me that you don't know the person. And so how did you apply for pre-settled?
Mm-hmm.
And number two, after pre-settled, did you not live with your wife or husband
Yeah.
before divorce? If you did, at the time you got your 5 years, you started working. Your sponsor was already working or living in the UK.
Mm-hmm.
So even if you didn't have proof of address before your 5 years, after your 5 years, you had proof of address. So where is it? Were you living together or you were living apart? If you were living apart, then how did you get your pre-settled through relationship? And if you were living together through that, you got your pre-settled. How come you are saying that you don't have anything at all from the beginning?
Mm-hmm.
Corroborative evidence.
Evidence, yeah.
So I'm saying something here because there's strength for those applying on the basis of their retention of right.
Mm-hmm.
So let's be mindful. Right. One other thing that has become manifest is that most people who apply for indefinite leave to remain, which is settled status, they have forgotten that they apply for 5 years pre-settled. And at the time, they provided some evidence or documents.
Mm-hmm.
When they are going now for indefinite, they will bring something up, which is their file, and they will refer to what they provided before. And they will tell them that what you provided us 5 years ago, we have realized that it was fake. And so, if it was fake then, how can we trust you today
Yeah.
with what you are bringing for indefinite?
But lawyer, when they say that it was fake, is the burden not on them to prove it?
When they say it is fake, they will transfer the burden to you to prove it because it's a resumption that must be rebutted.
Mm-hmm.
The presumption is that this evidence is not genuine. And if we had known, we wouldn't have given you 5 years. But having known at this point when you are coming for another visa,
Mm-hmm.
we have referred to your file and realized that what you brought before, there are issues. Can you now explain to us if this was the case or not? It is now up to you to rebut the presumption.
I I I get your point, maybe technically, but then to me, I brought you something that I know is genuine, and you are saying it's not genuine. Then why don't you tell me why you think it is not genuine? Then
They
I
will
can
tell
give you
you.
an answer rather than throwing it at me and say prove it.
No, they will tell you why it is not genuine. They will tell you
Okay.
that we have verified and realized that the tap money transfer receipt you brought, or
Mm-hmm.
the bill from or the bill from T-Mobile, or the bill from Eon, the energy
Mm-hmm.
company, or the
Yeah.
bill or the bank statement from Monzo, from here, we've realized that they are not reliable or
Okay.
credible. At this
Oh,
point,
obviously. Okay.
they've told you that we checked the Monzo record and yours is not one of them. So can you come and prove to us? So at that point, you can't say you didn't know. And they have told you what you sent to them, and they will give you date. And that could be reason why your settled status application may be refused, because they doubt what you had before and they are doubting you now.
There's an interesting question that just crossed my mind. You have pre-settled status. Now you're going for your settled status and your application is refused. What happens to your pre-settled status? Are they going to revoke that as well?
If they don't say that because of deception, we
Mm-hmm.
are going to attack the visa under paragraph A3 of the rules,
Mm-hmm.
then you are okay. But if they say that we are going to attack it, because paragraph A3 says that if after grant of the visa,
Mm-hmm.
it comes to light that things that was provided to the caseworker, if the caseworker had known the visa wouldn't have been granted,
Mm-hmm.
then the caseworker can go ahead to cancel or to withdraw.
Okay.
So normally with that, they will give you minded to cancel notification. But where the issue is not about that bit, then we are saying that we won't give you indefinite leave to remain. Under the EU rules currently, EU nationals and EU family members on 5 years cannot be forced to make an application for indefinite. It's not compulsory.
Okay.
And if it is not compulsory, you have to keep renewing my 5 years for me. And I don't have to come again to renew the 5 years. And so what am I going to get? Automatic renewal.
But that one way or the other is equal to indefinite.
It's not indefinite, because indefinite means you have no restriction. Five
Okay.
years means you have restriction. But some people don't want that, even though you have it for life, as we said. But that is also indefinite because you are going to get it for life. Some
Mm-hmm.
people don't want to hear pre-settled. They want to say that me, I
I'm
have
settled.
settled status,
Okay.
so that they can live their life knowing that they have no immigration control. So
Okay.
even though presumably you have something that will stay with you for life or that you can have for life, that's not what they want. But whilst going for what you want, things can come up. And so when it becomes apparent that you cannot continue on the indefinite leave to remain tangent, you just give up and rely on the 5 years, which is auto renewed every 5 years.
Oh, okay. Well, we're live with Lawyer Charles Asma from BWF Solicitors. We're live on BWTV, and the program is The Community and the Law. Why are EUSS applications being refused? Is there a solution? Lawyer Charles Asma is taking us through that. At this point, I'm going to take your questions, your concerns, and your phone calls. 0208 is the number to call us on. If you have a text, WhatsApp, or any message you want to throw it over to us, is 0739920846 or you can keep them in the comment section down below at BWF Solicitors, at BWTV, both on Facebook and YouTube. Let's quickly pick these ones. I wish you a very good Saturday. Thank you very much. I was granted limited LTR Well, lawyer would do that for me. I was granted LTR through my
That's
child
live
on
to
a
remain. Live to remain.
leave to remain. Okay. Through my child on a 10-year route. I eventually switched to 5-year route as a parent. I married the mother of my child, but we separated after a year. I just received my indefinite leave to remain in December, and this month I've patched up things with the wife, and we are now living together. I want to find out if I can apply for naturalization, considering that my wife is a British citizen, or do I still need to wait for 1 year?
That's a good thesis statement.
Mm,
Now let's go into the thesis. First, this person got it as a parent
yeah.
and switched to 5-year parent. And at the time the person switched to 5-year parent, they had separated from the mother. And so the child was living with the mother and they were living apart.
Hmm.
And so they applied on the basis of their direct access to the child. And that is the only way they could switch to 5 years parent.
Okay.
So there's no spouse here. Then he said that I married the mother of my child, whom I separated from a year later.
Hmm.
So now mother, child, and father are living together. But
Yeah.
this father is still holding on to 5 years as a parent, right?
Hmm.
But that's the story.
That's the
He
story.
didn't
Yeah.
say that. He didn't say that when I married her, I switched again to partner. He said that I married her, and the next one is I just received my indefinite. The question is, did he get the indefinite from the 5 year as a parent or 5 year as a partner?
That's a question he's asking, isn't it?
And no, that's not a question. It's the point that was missing.
Oh, okay.
So he had his 5 years as a parent, which is a fact in there. He married the lady later, and they are now living together. But when he
Together.
married the lady, did he get another visa again? No, there's
No.
no mention.
Yeah, he didn't
And
mention that.
therefore, we can deduce from here that the 5 years is given as a parent when he was living apart.
Okay.
So, having now received your indefinite leave to remain, you received your indefinite leave to remain as a what? As a parent. If it is as a spouse, then who is the spouse? British spouse. But this one is a parent, so it is the child, not the spouse who gave him the 5 years. And
Mm.
so you can't say that I've now married her, even though I had it from my child. And so the virtue of that marriage should give me advantage under the rules. No, you don't have 5 years from you don't your indefinite was not given to you through the spouse. The indefinite was given to you through what you had as a parent. Even though at the time of the application for indefinite, maybe you would have said I live with my wife and all that. You are not applying for indefinite, and therefore we can see that the indefinite leave to remain form wouldn't be set M. He should come back and tell us whether it was set M. If it was set M, that means it was based on the marriage. Then he can go for naturalization immediately. But if it wasn't set M, then he can't because it doesn't give him opportunity under that route.
Okay, so our dear friend, if it is that you want to provide that detail, the answer will be giving you. Let's move on to another one quickly, and this one is from Citizen Kwajo. Now, Citizen Kwajo says Soma Obi is a German national with pre-settled status in the UK. Lawyer. She was granted pre-settled status in 2020 but left the UK after approximately 1.5 years due to a family emergency. She returned to the UK earlier this year. Her pre-settled status is due to expire on the 12th of July 2026. Now, the question is what options does she have to apply for settled status, given that she's not lived and worked in the UK continuously for more than 2.5 years? Lawyer.
Okay, so the rules say that if you're applying under Appendix EU to the immigration rules paragraph EU11 is the settled status. That's what she wants to do, isn't it?
Mhm.
EU11 says that you should have, prior to your application, been resident in the UK for 5 years. Has she been resident in the UK for 5 years?
No, because she left due to a family emergency.
If the answer is no, then she cannot meet the requirement. Because what the story is telling us is that approximately 1.5 years due to family emergency, but returned this year. The person got 2020 visa. Let's do the calculation.
Mhm.
2020 plus 1.5 will be what? 2020. That's so
2020, middle of
2021,
2022.
middle of 2022, right?
Mhm.
But the person
Middle
is
of
telling us.
2022 to 2026, which is 3.5 years.
So the person is also telling us, even though they've been away for 1.5 years, he says after approximately the person left the UK after approximately, so they lived for 1.5 years and never came back. So they've been away longer than required to be able to say that the person is ordinarily resident in the UK,
Mm.
exercising treaty right. What can the person do? The person should be able to make up for the difference. Now they've returned. The 5 years will be auto renewed. And once they've made up for the difference, they can apply for settled status.
Okay, so the 5 years will be auto renewed, and when they have lived here for 3.5 years that they may have missed from the first point, then in the middle of that 5 years, they can go for their indefinite. Is that correct?
Well, so if I say to make up for the difference, let's clarify. Because the person has been away and returned this year, 2026,
6.
right? You can't say that I have 1.5 years in the bank, so I'm going to live 3.5 years to make up.
Mm-hmm. Okay,
It's now returned, and so you are going to live your life from now.
for another five
So
years.
once the thing is auto renewed, it is auto renewed for 5 years.
Okay.
So then once that 5 years is up, you can apply for settled status. Otherwise, the person can just test the law and see whether there could be exception to the rule that it has to be 5 years, citing emergency and whatever happened away while the person was away. If it is medical, or the medical evidence to support the claim that they became unwell or whatever happened there, then to see whether they will accept it on that basis.
0208493745 is the telephone number to the studio. And if you want to text, you can text us on 07399208468, or leave that in the comment section down below, either on Facebook and or YouTube at BWF Solicitors and at BW TV. Let's pick up the next one. Please, can I still apply for settlement? My children have Italian passports.
Your children have Italian passport. When did they become your children? When did they enter the UK? And where are you living? It's all vague.
Hmm.
Where are the children and where are you? Settlement, pre-settlement, or settled status settlement.
Felicia, give us some more details. That would be very useful so lawyer can give you a very accurate answer, as it were. 0208493745. Comment section down below. Let's pick up the next one quickly. When can you apply for indefinite leave to remain when you first gain your limited leave to remain in June 2015 without any gaps? Can you make an appeal if your indefinite leave to remain is refused? When can you apply for a British passport or naturalize your children who were born in 2024 and 2025 after you gained your indefinite leave to remain in 2026?
Can we leave
So,
the question on the board?
yes, we can leave
So
it there.
question,
Let's see.
right. So question one. When can you apply for indefinite? When you got your limited leave to remain, I suppose the two and a half, June 2015. And there have been no gaps. So if there have been no gaps, June 2015 plus 10, 2025, your 10 years would have been June 2025. So you can apply for indefinite from June 2025. The next one, can you make an appeal? Can you appeal if your indefinite leave is refused? Yes, you can. The next one, when can you apply for naturalization? You can't apply for passport if you're not naturalized. So how can you apply for naturalization? Okay, when can you, okay, let me just go by this. When can you apply for a passport to be able to naturalize your children? So you can apply for passport when you have naturalized. Once you become a British citizen, you can apply for passport the same day you became a British citizen. After you have done your ceremony, they give you a certificate of citizenship, and the same day you can apply for British passport. The second part to that question is, and when can you naturalize your children who were born in 2024? So children born in 2024 can be registered to become British citizens. But again, we don't know where the children were born. If the children were born in the UK in 2024, because you have indefinite leave to remain, you can apply to register your children to be that child to become a British citizen. That is, if the child was born before your indefinite. If the child, because the person also says that, can I appeal indefinite leave to remain refusal? It tells me that they haven't gotten the indefinite leave to remain yet. So if they haven't gotten the indefinite leave to remain yet, they have to wait. Once they have the indefinite leave to remain, the person can register the child if the child was born in the UK. If the child was born abroad, then you can register the child. The next one is the child born in 2025, the same scenario for 2024 child. After you gain, okay, and then after you gain your, all right, in this case, after you gain, so it says indefinite leave to remain in 2026. So we have another information. So the person has the indefinite leave to remain in 2026. If you have your indefinite leave to remain in 2026, then soon as you have your indefinite leave to remain, you can register the child born in the UK in 2024 and the other child born in the UK in 2025. You can register them to become British citizens under Section 1, Subsection 3 of the British Nationality Act 1981.
Well, we'll take one quick one and then ask Laura to help us answer that calculation when we did about the savings and the rest of it. Felicia, and then I'm living in the UK. My children are in Italy. I think that's a follow up to the previous question that said that the children are Italians.
So if your children are living in Italy, they are living their lives there as Italians. You are living in the UK, your children cannot sponsor your application to remain in the UK because these children are not qualifying children. Unless you are telling me that your children were living in the UK and they went to Italy on holiday, they are coming back. If they are coming back and they already have 5 years leave pre-settled status or indefinite leave to remain under EU, then you, the mother, can apply for 2.5 on the basis that you have children who are qualifying children. If not, you cannot.
Okay. I said I was going to, but if I could get this one quickly. Somebody is asking, when can you apply for indefinite leave to remain when you first gain your
2015,
Oh,
right?
okay, okay, okay. I think we've answered that question.
We're done, yeah, we're done with that.
The person was trying to be smart and brought it to my phone. We have answered that. Thank you very much. So, yes, now let me go to the nugget and quickly run through it and see what answers I'll get from here before I put that to Lawyer Charles Asma. An applicant for entry clearance as a spouse can rely on savings to prove his or her finance where he or she does not have sufficient income for employment or self-employment. To rely on savings, the amount should be a specified savings of £16,000 and additional savings on amount equivalent to 2.5 times the amount, which is the difference between the gross annual income of 29,000 and the actual income the applicant or the sponsor receives. So that is 16,000 plus 29,000 minus the actual gross annual wages. So let's see what the scenario was and what answers we can get. So Sanusi intends to make an application for a visa to join his wife Anna, so to speak, who has indefinite leave to remain in the UK. Anna works part-time and earns 12,000 gross per year. Sanusi is unemployed, but has savings income that he wants to rely on for his application since his wife's income does not meet the 29,000 salary needed for his application, for his visa application. So how much savings should Sanusi have in the bank to make his application possible? 58,000, 58,500, 16,000, or 29,000? Let's see what answers I have before I put it to lawyer Asma quickly. Um, Ziggy Ofori says it's A, that is 58,000. Ziggy, thank you. Next, we have one from Sonia Mafo, C, 16,000. Sonia says it's 16,000. The next one is from Kofisa Akodia, 58,000. Thank you, Kofi. The next I have as an answer is from Elijah Danso, who says 58,500. Let me take just a couple more and I'll see what answer there is. Chris also says is D, 29,000. And then Betty Ohiniwa is saying it is 58,500. Desmond Danko says it's 58,000. Okay, lawyer, let's see. Can I take my calculator again?
Yes, this one there, you and I are going to test ourselves. We know
Okay.
the formula. The formula
So
is A. A is 16,000 plus
16,000, yes.
plus 2.5 into bracket X minus Y. So that is algebra.
Okay.
So
So
the X is the 29,000. So we do the bracket first. X is the 29,000. Y is the money the person earns.
So the person earns 12,000. So then that's 17,000. That's the
So
difference.
29 minus 12 is 17,000, right?
That's the difference, yes.
Then times 2.5. So times 2.5.
Times 2.5, and that's
Equals
42,500. Then we add 16,000.
16. Yes.
16,000. So the answer is B, 58,500.
So let's show how it's done.
Okay, so yeah, the answer is B, and as we said, 16,000. And Laura says should do the one in the bracket first, which is the 29,000 that's required, and the actual income that Sanusi's spouse Anna earns, which is 12,000. So we get the 17,000, then multiply it by 2.5, and then we take that from
We add.
we add that to 16,000. Yes, we take that as the one in the bracket. So 17,000 times 2.5, then add it to 16,000. It's 58,500. So those of you who said B, you are correct. This is from paragraph E, ECP 3, subparagraph A, and subparagraph 1 and 2 of Appendix FM to the immigration rules. Well, I quoted the source because lawyer would have asked me, where did you get that from? So I'm learning.
That's good. You're a very good student.
Yes. Lawyer, I would want to say thank you to you again for your time. But before then, if you could spend a minute to let us in on what we discussed this afternoon.
Sure. Ladies and gentlemen, viewers and listeners, today we looked at why are EUSS applications getting refused and what are the solutions or way around it. We understood that most people applications don't even pass the validity stage because they don't have reason why they are late. We are in 2026, and if the person didn't apply until now, then they have to show why they didn't. What could be your reason? Were you a seaman working at sea, and so you've been away, or were you unwell for all these years? Were you in prison? What is the reason? Is it about family issues? You must provide evidence to support that. And if the evidence is acceptable, then application will move to the next stage. Once application moves to the next stage, the caseworker must assess and make a decision. The assessment is either to refuse, after the assessment is either to refuse or to grant. The refusal reasons could be that one, you don't meet the relationship requirement because you couldn't prove that this is a genuine relationship with your wife or spouse, or you couldn't prove that this is a genuine relationship with their mother or father, couldn't prove that this is a genuine relation with their grandmother or grandfather, and you couldn't prove that this is a genuine relationship with their child. If you can't prove the relationship, the application will be refused because you don't have a family member to sponsor you. Another reason could be that you don't have evidence to show dependency, especially if you were a child, 21 years and above, and applying based on your grandparent or your parent who are EU nationals. The dependency means that the person depends on these sponsors or this sponsor for their essential living needs, clothing, shelter, food, and also non-material financial support. Here we're looking at emotional support, psychological support, and other aspects of life needs. If you can put the two together, you are able to meet the dependency threshold. If not, application will be refused that you do not meet dependency. If you are a child under 21, then you don't have to prove dependency. If you are a parent, you don't have to prove dependency as well. If you are a parent but a mother or father-in-law, then you have to show dependency because there is a bit of extension to biological parents, so you show dependency. The other reason why most people will be refused is that they applied on the basis that the relationship is broken down, so there is divorce. But they couldn't provide evidence that before the divorce they were living together. And so you couldn't show that there was living life with that person before divorce. Application will be refused. Again, most people will apply for settled status right after the breakdown of the relationship or death occurred. But they haven't done 5 years on the pre-settled status or from the date of marriage. Therefore, you don't qualify for settled status, application will be refused. We also touched upon the fact that most people will claim that they are applying based on their parents or grandparents in the UK. Meanwhile, they traveled to the UK a year or two ago, and when they were coming on their student visa application or visitors visa application or skilled worker visa application or any other visa application, they were asked, do you have anybody in the UK? They said no. So how come all of a sudden you have somebody that you want to sponsor your EU application? It doesn't make sense. Most people, they also caught up on relationship on the basis of calculation or age. You have somebody who is depending on the parent, and the difference between his age and the parent age is 5 years or 10 years. So how will you prove that your mother or father who gave birth to you was 10 years at the time or 5 years at the time? That defeats logic. Application will be refused. Again, some people may be applying based on their grandparent or grandparent, and so they are able to show that their mother gave birth to them and their grandmother gave birth to the mother. But between their mother's age and the grandmother's age is about 5 years or 10 years. It doesn't make sense. How can you say that at the time your grandmother gave birth to your mother or father, he or she, in terms of their grandparent, was about 5 years or 10 years? Again, it defeats logic. These are pieces of things that call for refusal, and the caseworker will say that you do not meet the requirement because you haven't been able to satisfy them. Therefore, let's understand them and provide reasonable excuse for validity and also provide the evidence they want to see for dependency, for relationship, and life on the 5-year route before you applied for settled status. If you're able to do all this and you take your time to go through the application process, you should be able to be granted. And if not, you can fight it in court. That is the only way to get around the refusal. We should take our time and work through. It is done if you know how to do it. If you are not sure, always contact a lawyer who will work with you until the evidence is up to it before you can put in the application?
Well, as the advice has gone, if you are not sure, speak to a lawyer who knows what they are doing. And I recommend that you speak to BWF Solicitors on the fourth floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters, North London. 0208 493 7340 is their telephone number. And you can call emergency situations on 077 BWF Solicitors are trusted partners when it comes to the law. And they bring us the Committee on the Law live on BWTV every Saturday afternoon between 4 and 6 p.m. UK time. Thank you very much, Lawyer Charles Asma, for spending time with us and also going on the community outreach to help empower people when it comes to the law. That's what BWF Solicitor does. So I would want you to patronize their services and give us some feedback when it is that you have enjoyed what they have given you. It's been another edition of the community and the law. And this afternoon, as we mentioned, we discussed why EUSS applications are being refused and what solutions there are to that. BWF Solicitors, we thank you so very much. And we would also want to share our condolences, as we have expressed it, with everybody out there. And we send them to lawyer EUSS Achampong, who has lost her mom. As I said, the details will be provided very soon. But remember, the week ending the 29th, 20, from the 25th of March, I should say, we will be having the burial service, the burial and the Thanksgiving service. We'll be sending you details along other line. So, EUSS, our condolences, and we pray that the good Lord will continue to give you the strength to stand in these difficult times. It's been the committee of the law, as I said, my producer, Professor Ade, Sheila Ankra, the admin person, and of course, Padmo Dodu for the aesthetics. My name is Ureku Frimpong. Have a good evening.